WGPR Detroit HD2.
You're watching WHPS, Highland Park, Detroit.
FM 88.1 WHPR, Highland Park.
WVIE 107.3 FM Charlotte, Amalia, Virgin Islands.
The views and opinions expressed on the following show are not necessarily the views and opinions of WHPS, its affiliates, management, or sponsors.
Hello, welcome to Know Your Rights, sponsored by Innocence Maintained. Aaron Salter founded Innocence Maintained as a way to help returning citizens, the wrongly accused and wrongly convicted, transition back into society. My name is Judge Michelle Rick. I serve on the Michigan Court of Appeals. I am a district director of the National Association of Women Judges, and I teach a class at Detroit Mercy Law School called Access to Justice. In addition to the regular coursework that my students do, every student is required to complete 30 hours of volunteer work in order to help people have access to justice. Today, I am here in the studio with two stellar students, Emily Myers and Brooke Nosachuk. They are going to give you legal information on two topics, voting rights and qualified immunity. And before they get started, I just want to remind you of the legal limitations of today's presentation. The information you are about to receive is only information and should not be considered legal advice. The information and research by Detroit Mercy Law students is provided for informational purposes only. And with that, I want to turn things over to Emily, who's going to be speaking to you about voting rights. Emily, take it away.
Awesome. Thank you so much, Judge Rick, for that introduction. It is amazing to be here. My name is Emily, and I will be here to talk about voting rights in light of the upcoming election on November 2nd. The purpose of our presentation today is really to explain how to vote, how to register, how to provide a safe and secure election, and to give kind of examples of how we can provide the community with more resources to make voting a lot easier. I would like to start off with just a short, brief history of voting rights in the United States. So, as a lot of us know, in 1776, the Declaration of Independence was signed, and Thomas Jefferson wrote, "Governments are instituted among men, depriving their rights and powers from consent of the governed." Can we go to the next slide, please? In furtherance of a little bit more history, in 1870, black men were granted the right to vote. The 15th Amendment is ratified to be in the Constitution, which ensured that people could not be denied the right to vote because of their race, granting black men the right to vote. In 1920, women were granted the right to vote. After decades of protests and struggles for change, the 19th Amendment is ratified, granting American women the right to vote. Can we go to the next slide, please? Awesome. So that's kind of a brief history of black men and women's writing votes. And the next slide indicates that just a little bit more history is that the voting rights in the 1960s were a continuous struggle, particularly in the South. Many states produced policies such as literary tests, poll taxes, and English language requirements, which really suppressed the vote of people of color that were wanting to vote, immigrants, and low-income populations. In 1964, the 24th Amendment was ratified and targeted poll taxes. The premise of a poll tax was to force people to pay money in order to vote. The payment of the tax was a prerequisite for voter registration in many states. The taxes were expressly designed to keep African American and low-income people from voting. In 1965, President Johnson signed the Voting Rights Act, which outlawed discriminatory voting practices in southern states following the Civil War. In 1971, 18 years and older voters that were citizens of the United States could vote. In 1975, votes for non-English speakers were granted the right to vote. In the early 1990s and the 2000s, we continued change. One of the most notable changes was in 2011, restrictions to voting passed in South Carolina, Texas, and Florida are found to be unfair to minority voters. The main focus of today is to explain that even if someone you know, you personally, or a family member has a felony conviction or a misdemeanor conviction, they are still granted the right to vote. In the United States, it was common to make returning citizens ineligible to vote. Over the decades, there has been a positive movement to restore voting rights of people with felony convictions, but the policies vary from place to place. In most cases, automatic restoration does not mean that voter registration is automatic. This means that even if you are a returning citizen, you must still register or re-register to vote if it's been a while since you have voted. I wanted to give a quick comparison of the different states and their restoration of voting rights. In the District of Columbia, Maine, and Vermont, returning citizens never lose their right to vote, even while they're incarcerated. In 21 states, returning citizens lose their voting rights only while incarcerated and receive automatic restoration upon release, which is the case in Michigan. In 16 states, returning citizens lose their voting rights during incarceration and for a period of time after, typically while on parole or probation. Voting rights are automatically restored after this time, and former returning citizens may have to pay fines, outstanding balances, or other things required of them before their rights are restored. In 11 states, returning citizens lose their voting rights indefinitely. Those states are Kentucky, Virginia, and Iowa, and often require a governor's pardon to be able to vote. We're going to focus on Michigan. So, this is very important. Your voting rights are only lost while incarcerated. That means that if you are awaiting arraignment, which means that you're waiting to go in front of a judge to formally hear the charges against you, awaiting trial, which can take a very long time given the COVID era that the court system is having to combat. If you are charged with a felony but not convicted, if you are newly released from jail or prison, on parole or probation, in the process of appealing a conviction, or if you are in jail but waiting to start trial, you can still vote. Your voting rights are only restricted while incarcerated. Our next slide kind of gives another brief overview of the lack of restrictions. So there are no restrictions in Michigan on post-prison voting. The day you are released from jail or prison, you can go vote in your state or federal election. There are no restrictions on your right to vote after serving your time. No permanent address is needed, which means that you can still register to vote using a street corner, a park, a shelter, or any other place that you usually stay at your address. There are any place where you can receive mail is enough to be considered your voting place, your voting registration place. You do not need a driver's license to vote. Any other state ID that's issued, a federal or government ID that's issued, IDs from other states, military IDs that have a photo of you, valid student IDs, or tribal ID cards are also accepted as a form of ID. So it does not have to be just a driver's license. There isn't a huge distinction between having a misdemeanor or a felony and your voting rights. It's more about the time that you're incarcerated. So,
serving your sentence, correct?
yes.
Thank you.
Yes. So when you're serving your sentence, you're not allowed to vote. Can you register to vote if you have a criminal record? Yes. Once you have been released, you may register and you may vote. Can I register if I'm on probation? Yes. Sometimes this requires that you have to get permission, special permission from your agent. If your agent is unwilling to give you permission, then you can just go ahead and talk to their supervisor because you still have a right to vote on probation or parole. Can you register to vote if you are serving a sentence? Whether you can register and vote while you are serving a sentence depends on whether you are serving a sentence in a jail or prison after being convicted or being detained pretrial. Can I register to vote if I'm serving a sentence? No. If you are currently serving a sentence in prison or jail, you may not register or vote. If you are a pretrial detainee, you may register and vote while you're awaiting your conviction sentence. If you are not serving in the same state that you live in, you just need to, that's fine, but you just need to make sure that you register where you lived previously.
And if I can just interrupt for a quick moment,
Yes, please.
and that is the reason why anyone can vote while they are awaiting trial is they're presumed innocent. Everyone is presumed innocent until they're convicted. So in addition to the notion that, up until the time of trial you can vote, it's very clear that your outcome might be a not guilty, or the prosecutor may dismiss the charge, but however the resolution happens, until the time that someone is actually convicted, they have the ability to vote.
Correct. Yes. Thank you, Judge Rick, for making that. It's a very important point because you still have that right to vote. Some important dates on our next slide kind of outline the next general election as well as the primary. And just as a quick reminder, wherever your polling place is, they're open from 7 a.m. to 8 p.m. And so long as you are in the line to vote by 8 p.m., you are still allowed to vote. There are a couple of counties that are listed on the slideshow. Those are not exclusive, which means that every county, I just picked the ones that were local, any county is going to be voting on November 2nd. So the statewide elections for 2022, August 2nd, 2022 is the primary, and then November 8th, 2022 is the general election. So put those in your calendar. We all have iPhones. Put a little reminder. Make sure that you go and vote out there. I did want to highlight a couple of the proposals that are going to be on the November 2nd ballot. So there's three proposals. Proposal E would decriminalize therapeutic use of some hallucinogenic plants. This simply means that the Detroit Police Department is not going to go out actively looking for people who may be using these hallucinogenic plants. Proposal R is establishing a reparations task force to make recommendations for housing and economic development. It's important to note that Proposition R is going to initiate the program, but the funding is going to come from subsidies and grants. And then Proposal S is giving the mayor initiative to change a budget. So that gives the mayor a little bit more flexibility with how he wants to conduct the budget for that. On our next slide are a number of free resources that are going to be available for your use. If you have any questions, any of those resources can help you, and they can explain how to vote, where to vote, how to register, if you're an absentee voter. And then it kind of there's another link on the explanations on all the propositions. And some final things to consider as I wrap up here on our next slide is that if you haven't voted in a long time, or you move to a new city or township, you have to re-register. If you move within the same city or township and you're already registered to vote, you only need to update your address. To Judge Rick's point, if you are awaiting arraignment or trial, you can still register to vote and you can still vote. Finally, the Michigan Voter Information Center has tons of resources, and they can give you more information on how to vote, polling places, people that are running for election, and the propositions. This concludes the portion of voting rights and election information, and now we're going to switch gears to talk with Brooke about qualified immunity.
Hello, everybody. Like Emily said, we are going to pivot the conversation to qualified immunity. First, I'd like to start off on the next slide by stating the protests ignited by the killing of George Floyd have put a spotlight on the legal doctrine of qualified immunity. And while qualified immunity wasn't at issue in that case, it is one of the many structural factors that make it difficult to hold police officers accountable for wrongdoing. Qualified immunity is a judicially created doctrine that shields government officials from being held personally liable for constitutional violations. The landmark case of Harlow v. Fitzgerald articulated the modern formulation of qualified immunity that controls today. In overview, qualified immunity is a type of legal immunity. In other words, it is a protection or exemption from something, like an obligation or penalty. It's a defense brought by a government official. Qualified immunity balances two important interests. One, the need to hold public officials accountable when they exercise power irresponsibly, and the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. Qualified immunity applies only in civil lawsuits, not criminal prosecutions. So how does qualified immunity work? Specifically, qualified immunity protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated a clearly established statutory or constitutional right. When determining whether or not a right was clearly established, courts consider whether a hypothetical, reasonable official would have known that a defendant's conduct violated the plaintiff's rights. So courts conducting this analysis apply the law that was in force at the time of the alleged violation, not the law in effect when the court considers the case. A clearly established right. To show that a right is clearly established, a victim must identify an earlier decision by the Supreme Court or a federal appeals court in the same jurisdiction holding that precisely the same conduct under the same circumstances is illegal or unconstitutional. However, if no decision exists, qualified immunity protects the official by default. So for example, when a police officer shot a 10-year-old child while trying to shoot a non-threatening family dog, the U.S. Court of Appeals for the 11th Circuit held that the officer was entitled to qualified immunity because no other earlier case held it was unconstitutional for a police officer to recklessly fire his gun into a group of children without justification. The court also declined to establish that rule. So not only was the officer let off the hook in that case, but the very same officer could act in the same way again and would still be entitled to qualified immunity.
And I see from your slide that you've shown not only the case name, but that it came out of the 11th Circuit, and that the United States Supreme Court decided not to take up that case to look at whether the result was fair or not.
That's
so
correct, Judge.
From the Supreme Court's perspective, that's going to stand.
Exactly. That's an important point. There are two qualified immunity cases that were recently heard by the U.S. Supreme Court. The names of the two cases can be found at the bottom of the screen. So in both of these cases, alleging excessive force, the U.S. Supreme Court reversed the denial of qualified immunity, emphasizing that a constitutional violation must be clearly established before officers can be sued. So in the first case, the justices said that the California officer did not have to face a civil rights suit after briefly placing his knee on the victim's back while the officer removed a knife from his pocket. And in the second case, the justices similarly said that the Oklahoma officers could not be sued for killing the victim who charged at the officers while preparing to swing a hammer. In both cases, the justices said previous case law had not provided the officers with clear guidance that their conduct violated the Constitution. Specifically, the court stated it is not enough that a rule be suggested by then existing precedent. Instead, the rule's contours must be so well defined that it is clear to a reasonable officer that his conduct was unlawful in the situation he confronted. Ultimately, the court found in both cases that the officers were in fact entitled to qualified immunity. In another case, the U.S. Supreme Court reversed the dismissal of an incarcerated person's feces-covered cell in Texas. In this case, an incarcerated person named Trent Taylor alleged that for 6 full days in September of 2013, guards placed him in an unsanitary cell that was covered nearly floor to ceiling in massive amounts of feces. The district court found in favor of the prison guards on qualified immunity grounds. On appeal, the Court of Appeals for the Fifth Circuit agreed and held that although Taylor's conditions of confinement violated the Eighth Amendment, it found that the law was not clearly established that prisoners could not be housed in cells teeming with human waste. The appeals court therefore affirmed the dismissal based on qualified immunity grounds. However, the Supreme Court of the United States found that to be an error. No reasonable correctional officer could have concluded that, under the extreme circumstances of this case, it was constitutionally permissible to house Taylor in such deplorably unsanitary conditions for such an extended period of time. Therefore, the Fifth Circuit's order was vacated. So who does qualified immunity protect? Qualified immunity only applies to suits against government officials as individuals, not suits against the government for damages caused by the official's actions. So although qualified immunity frequently appears in cases involving police officers, it also applies to most other executive branch officials. While judges, prosecutors, legislators, and some other government officials do not receive qualified immunity, most are protected by other immunity doctrines. Absolute immunity versus qualified immunity. Absolute immunity provides legal protection to judges, prosecutors, legislatures, and executive officials for actions committed in their official duties without malice or corrupt motives. Absolute immunity protects these individuals from both criminal prosecution and civil lawsuits. It's important to keep in mind that absolute immunity only applies to acts committed within the scope of the official's duties, and it does not apply to police officers, who generally operate under qualified immunity protections. Qualified immunity still offers several important legal protections for police officers so they can focus on keeping their communities safe without fear of retribution. Qualified immunity protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials clearly violated clearly established law. Like absolute immunity, qualified immunity shields police officers and other government officials from frivolous lawsuits, ensuring that they can make the best decisions for their situation without fear of legal action. So who has the burden of proof? Unlike most legal defenses, a victim or the victim's family has to convince a court that qualified immunity does not apply. All a government officer has to do is invoke the doctrine. If a victim can't persuade a court that qualified immunity should not apply by pointing to a specific earlier case, the victim's case is thrown out. And if the case is not thrown out the first time around, the government worker has several more opportunities to invoke the doctrine. Qualified immunity applies even when officials intentionally or recklessly violate the law. The primary consideration in a qualified immunity analysis is whether there's an earlier court case specifically stating that the particular actions of the official are unconstitutional. So for example, the Ninth Circuit Court of Appeals held that police accused of stealing over $200,000 while executing a search warrant were entitled to qualified immunity because that court had never addressed whether the theft of property covered the terms of a search warrant violates the Fourth Amendment. It did not matter that virtually every human society teaches that theft generally is morally wrong. It's important to note here that the Supreme Court left this standing, meaning that they denied the opportunity to rehear it, just as Judge Rick discussed earlier. Overcoming the qualified immunity defense. If a plaintiff overcomes an officer's qualified immunity defense, that does not mean the plaintiff wins the case. If a victim can overcome qualified immunity, which can be raised by a government worker in multiple stages of the litigation process, it merely means that a court will actually decide the merits of the case. It is still up to the plaintiff to prove that a government worker violated the Constitution and harmed the plaintiff. State versus federal qualified immunity. Both Title 42 of the United States Code, Section 1983, a statute originally passed to assist the government in combating the KKK violence in the South after the Civil War, and the Supreme Court's decision in Bivens, allow individuals to sue government officials for money damages when they violate their constitutional rights. Section 1983 applies to state officials, while Bivens applies to federal officials. Because damages often are the only available remedy after a constitutional violation has occurred, suits for damages can be a crucial means of vindicating constitutional rights. When government officials are sued, qualified immunity functions as an affirmative defense they can raise, barring damages even if they committed unlawful acts. Policy concerns leading to the creation of qualified immunity. According to the Supreme Court, qualified immunity is needed to make sure government workers are not deterred from acting in split-second decisions and that government workers do not face financial harms from a flood of insubstantial and frivolous lawsuits. Some states have begun qualified immunity reform. In the recent years, Colorado and New Mexico have both passed laws that give people who have been victimized by excessive force a way to file suit in state court charging that their state, rather than their federal, rights were violated. Most state constitutions protect the same rights as the United States Constitution, such as guarantees against unreasonable searches and seizures. New Mexico's law allows state lawsuits against all public officials, while Colorado allows them only against law enforcement. Here, you'll find some free resources regarding Michigan's attempts and efforts to reform. And at this time, the Honorable Judge Michelle Rick will discuss some of her experiences regarding voting rights and qualified immunity.
Thank you very much. We're going to take a break right here, and we'll be back shortly to wrap it up. So stay tuned.
There's a new financial empowerment center located in the Wayne County Treasurer's Office on the 5th floor of 400 Monroe in Detroit.
If you or someone you know needs help with their finances, budgeting, and making monthly payments, the Detroit Financial Empowerment Center can help.
Wayne Metro Community Action Agency has counselors ready to provide free one-on-one counseling to help you address issues related to utility bills, taxes, and other financial matters. We can also help you improve your credit score.
Hi, this is LaWanda.
This is R.J. Watkins.
Coming to you to bring you some information about the #1 detox in the nation, Lemon Burn. Lemon Burn helps to turn the fat into fit. It's for you, a happier, healthier you. Because you know healthy is the new beautiful. An all-natural way to improve your health. It promotes a healthy digestive system, attacks and reduces belly fat, as well as gives you energy. Need to get yours today. Call 313-868-6612.
Don't forget to exercise and eat right.
So welcome back. Thank you to our students, Brooke and Emily, who I'm going to introduce and allow them to talk just personally about themselves with you in a moment. They are two of the 18 students that I have in the Access to Justice class. And just so you, your viewers understand, the purpose of our class is truly to dissect the criminal and civil justice system, to brainstorm, to talk about what works really well and where have people left behind and what can we do as members of the legal profession to make things fair, to provide access to justice for all. And so one of the things that I ask my students when we start our class is to not only introduce themselves, but to also share why they took the class. Because, again, for viewers' purposes, law school has a number of classes that are mandatory, right, that lawyers have to take so that they're prepared to take the bar examination, which then, if they pass, enables them to represent people. And Access to Justice is not one of the classes on the list. of those mandatory classes. So students who come to this course do so because they have a desire. They want to learn more about the intricacies of the practice of law, how courts work, and they're problem solvers. They are looking to make a difference. And so, Emily, why don't I start with you? And if you don't mind just sharing with the viewers a little bit about yourself. And I'm not looking for brownie points here, but tell me, why did you take Access to Justice as a class?
Cool. Thank you so much, Judge Rick. My name is Emily Myers. I am a third-year law student at the University of Detroit Mercy School of Law. And it's honestly the best experience taking a class with a judge, because she has like the best experience. She gives parables in class, gives real world experience. And also I took Access to Justice because I am currently working on the criminal trial clinic with the Detroit Mercy School of Law, which is essentially its real world trial practice under the supervision of a licensed attorney. And so the premise, I kind of wanted to see how the two work in tandem, see where the shortfalls are. How can we improve the system to better help people of the Detroit metro area? And so that was a huge motivating factor for me, because I wanted to see, like, what areas can we improve and what areas are within our power to improve. So that was a main motivating factor, but also like taking a class with a judge, again, it's a rich experience. And for any law students that are thinking about going to law school, if you can take a class with a judge, do it. It's a really great experience. So.
Well, thank you, and I know that our new dean, Dean Jefferson, would be so proud of you talking about the experiences and how Detroit Mercy really does educate the complete lawyer, because
it absolutely does.
You are out in the community making a real difference, and Detroit Mercy requires that you do an experience.
It does, yes. We do have the discretion to choose whatever clinic we want, and I wanted to get in front of a judge in a not school setting, so that was why I opted for the clinic, the criminal trial clinic. But it is Dean Jefferson Exum should be very proud, because it's a wonderful program, and it's a great experience.
Fantastic. Thank you. Well, I'm going to turn to Brooke then and ask her the same couple of questions. Tell us a little bit about yourself and share with the viewers why Access to Justice as a class is important to you.
Yeah, so my name is Brooke Nosenchuk. I, like Emily, am a third-year law student at Detroit Mercy Law. I went to Kalamazoo College for undergrad, so it's good to be back on this side of the state. I've loved my experience at Detroit Mercy thus far, and especially my experience here in Access to Justice with Judge Rick. Actually, this class I have been wanting to take for my first year and my second year, and finally got into it this semester because it's been so popular. It really goes to show that it is a life-changing class, and people gain so much from it. So I appreciate the opportunity to finally get to spend some time with Judge Rick and learn from the incredible students within this class. So another reason why I decided to take Access to Justice is because I really wanted to help give a voice to those who struggle to advocate for themselves. That is a huge reason why I wanted to become a lawyer and why I want to become a lawyer. And Access to Justice has really helped us brainstorm some ways how to bridge the access gap, which is such an issue here in the United States.
Thank you for that. And, this concept of access to justice and kind of exploring the realities for so many who find themselves in what we call the justice gap is only possible because we have speakers who come in and share their stories. And Aaron Salter and Valerie Newman of the Wayne County Conviction Integrity Unit are two people that have connected with our class. This year we also heard from Marvin Cotton, another exoneree who spoke from his heart. And for law students to hear about these experiences with the criminal justice system that we like to hold out is as the best in the world, but it is not flawless. And that's why it's so important for our students to hear stories like Erin's, who had an attorney who didn't pursue a possible alibi defense. Or Marvin, who talked about identification issues and how once upon a time the law thought that an eyewitness identification was solid gold, and now we know that's not true. And it doesn't even have to be a reflection of fault or wrongful behavior within the criminal justice system, but things get layered on top of one another that can result in extreme injustices. And if any of you would be interested in reading kind of historic information about injustice, again, Detroit Mercy Law School has students read as a first year The Color of Justice, which talks, the Color of Law, excuse me. I want to always promote justice. But The Color of Law, which talks about how the federal government, communities, and a whole host of other individuals effectively used housing discrimination to create pockets, ghettos within communities to keep poor people of color and those who were not, shall we say, white privileged individuals confined in certain areas. And we also have read other books as well, Halfway Home, which talks about the struggle of family when a loved one is incarcerated and the many difficulties that are experienced because, of course, when you have someone who is convicted of a felony offense, they may not be able to live with loved ones. If loved ones live in public housing, they may not qualify for benefits. We've explored other aspects of incarceration, including the fact that inmates pay premiums for goods while they are incarcerated and the hardship that that creates in terms of their prisoner account and the family who is attempting to support them from beyond bars. But those are two examples. I don't know if anything else comes to your minds about the class that you find remarkable or that you think is worth commenting on.
Yeah, kind of just to echo what Judge Rick and Brooke were kind of talking about, getting the guest speakers that come in and all of the guest speakers that Judge Rick had just mentioned, it gives you a different perspective, right? Because the experiences that they're having, you don't think that, oh, well, that'll never happen to me, that'll never happen to a loved one. It gives you a really real, empathetic, sympathetic perspective because, it's not like the movies. It's not like Law and Order when they're like, oh, this lawyer, didn't do their due diligence. It's not really like that, So there's somewhat of a disconnect between there's a public misconception about what actually happens to people that are, returning citizens, that what their family members have to go through. In Halfway Home, one of the examples was that phone calls were really difficult. It gets really expensive to talk to loved ones that are currently serving or are convicted for whatever crime. That's just another example of you wouldn't think about that, right? So it really does, like I said, I'm trying to echo what Brooke said. It's an advocate for someone who may not have a voice, and it's bringing light to those kind of situations because you wouldn't necessarily think about it, So. Yeah.
Also, an advocate for those who don't know how to use their voice in the right way. Not even those who don't have a voice, but sometimes you just need a little help to actually get your voice heard. And that's, why Emily and I want to become lawyers, is to help those. Another book that we're reading in class, I don't know if Judge Rick mentioned this one, is The New Jim Crow by Michelle Alexander. I would highly recommend that book to anybody. It's incredible. It really highlights the mass incarceration issue that is being faced in the United States and compares it to that of the new Jim Crow. So the premise of the book is the mass incarceration problem that is here is equivalent to the new Jim Crow. And so it is, it's very valuable to read those sort of books in a class where it's very different type of classes compared to some of the other classes that we must take in law school. And so it kind of gives us a bit of a different perspective, looking at things differently, and being able to hear different guest speakers come in. It is very valuable to us as students.
I'm so glad to hear you say that. I hope it's not just because I'm sitting next to you that you feel that way. That when we talk about the new Jim Crow, basically that's using law enforcement of drug laws as a way to over-police, I think is the argument, the premise of Michelle Alexander's book, that has been overused and targeting areas that were, again, created, these pockets of communities created artificially with the idea that there's more crime there, when in fact that is not really an appropriate reflection of reality. But the class also delves into the civil side of law. Civil law, people are not, as a general proposition, entitled to an attorney appointed by the court. And we have explored ways that not only can students and practitioners help to lessen the justice gap, but we've also looked at the practice of civil law and the extreme limitations that exist even for those who do qualify for some form of legal aid. And as we delve into that piece or side of the equation, the students are required to read the Justice Gap Report from 2017 that was authored by Legal Services Corporation. And we're somewhat free-forming this conversation. It is not scripted, so I don't want to put either of my students on the spot, but I'm gonna. Emily, in terms of the Justice Gap Report, was there anything striking that you read about in that report about whether people even know they have a legal problem?
Right. So the Gap Report was really valuable because it gave really cool pictures that you could look at. It had a lot of graphs, and kind of it broke down like the percentage of people who didn't know that they had a legal problem. They didn't know where to obtain legal advice, what resources to utilize. So it is interesting from that perspective, because it's like, how can we better help these people? You know what I mean? Like what can we do through this class and provide resources to people so that they even have an understanding that it is a legal problem, that here are ways to figure out if it is a legal problem, what are the next steps to take. So that was like that is actually a statistic that I found striking. But there was a number of other statistics that are escaping me at this moment in time.
Well, maybe Brooke can help out with that as well. Anything take away from the Justice Gap Report?
Well, I don't know if this necessarily comes from the report, but something that popped up into my mind was the fact that a lot of individuals who have court hearings don't meet their attorneys until 10 minutes before they're actually up in front of a judge. And I think that is a huge issue, because you have to get to know your attorneys in order to have them advocate for you in the best way possible. So I don't know if you had any thoughts on that issue, or how we can better make it so people are helped and seen with their attorneys prior to their actual court hearing.
Well, I can tell you, when I was a trial court judge, which I did for 14 years, that it was for a long while not uncommon for people to come in and say, I haven't had a chance to talk with my lawyer yet. And it seemed to me that was a necessary conversation before we held court, so that those conversations and those strategies could be mapped out. In a criminal context, people are entitled to have counsel appointed for them at public expense, though there are ways that the public can recover the cost of that attorney afterward. And I know that our Supreme Court right now is looking at whether the court's imposition of financial obligations, particularly for in the criminal context, whether there is a conflict of interest between the court who is assessing that cost and the litigant who bears responsibility for that cost. But on the civil side, ordinarily litigants and their attorneys had an opportunity because they would have been retained before coming to see me, so they would have had an opportunity to speak ahead of time. But as we've kind of talked about, legal services which is an entity funded by the Congress, can only afford to represent a certain number of people, and there are so many people who are left out. And in order to determine whether the Legal Services Corporation, or legal aid as you may know it, is able to represent, ordinarily it has to be of a case such as a family law case or a domestic violence involved case, and there are thresholds. So if a family of four is at less than 200 times the federal poverty limit, then they may not have a problem qualifying for legal aid as long as they've got the right kind of case. On the other hand, if that same family maybe works 40 hours a week, $15 an hour, they may fall $1 above the federal poverty limit. Now, I haven't crunched those numbers, so I'm asking you to suspend reality a little bit with my hypothetical. But the point is, if you are a litigant who is impoverished but makes just $1 more than that poverty level, then you might not qualify for legal aid. And then the question becomes, what happens to these people? Many times they show up and they don't know what to do in court. And so for my students, we talk about what are ways that we can do a better job to assist. What we know is that taking on pro bono clients, which means volunteering free of charge for a case, that even if every lawyer in Michigan were to do that, there would still be a justice gap. So there would still be people who would have legal problems and wouldn't know what to do necessarily. Courts have undertaken some measures. I'm proud to brag about our Chief Justice, Bridget Mary McCormick, who had spearheaded several groups within the state to look at legal reforms, both in terms of civil justice as well as criminal justice. And there have been sweeping changes with our indigent defense for those individuals who have been charged with a crime and are entitled to an attorney being appointed for them. We now have in place rules that and standards that have to be adhered to so that the lawyer can spend more than 10 minutes before the case in order to get to know their client. They will have resources that are available that previously were not available to them. They will have the ability to charge a fee and be reimbursed at a reasonable rate so that they can take the time to spend with their client. And then they also have the ability to do outreach, to have investigators so that they can better have, their lawyer has a better ability to pursue defenses when people are charged with crimes. So, I want to just very briefly, in terms of our presentation here, give a couple updates as I was preparing. We hope you've learned something from our discussion, but just today, Governor Whitmer vetoed 3 bills in our state legislature that would have impacted voters. So we talked about voting rights. And I learned this information from ABC 12's website, that according to that website, Senate Bill 303, which was presented to the governor for signature, would have required voters who vote by no reason absentee, and I'm one of those, that they would have to put their driver's license or state identification card information or the last 4 digits of their Social Security number on their absentee ballot, and Governor Whitmer said no to that. Senate Bill 304 would have placed nullified votes cast by people who showed up to the polls and didn't have their identification. It would have nullified their vote unless they returned with proper identification. And then House Bill 5007, which was also vetoed, would have given voters without identifications a right to obtain identification cards for free. Now, the website I quoted, ABC 12, indicated that while the governor vetoed those 3 bits of legislation, that there is a petition effort underway by an organization, Secure My Vote, and they are going around collecting signatures. If they collect enough signatures, these 3 bills could be passed by the legislature without having to go to the governor's desk. So it's important to know what you're signing if you're asked to sign a petition. Please read the petition before you sign it, and know that it can have consequences. Additionally, it would appear that qualified immunity is here to stay based on the recent United States Supreme Court cases that Brooke talked about. And in other words, it would take an act of Congress to do something to change qualified immunity, at least on the federal level. And according to a recent article in the Washington Post, the United States House earlier this year had passed the George Floyd Justice and Policing Act, which would have restricted the use of qualified immunity in federal cases. And that was then pushed over to the other house, known as the Senate, and the Senate has not taken up that legislation or that proposed legislation. And so there's an uncertainty on the federal level whether there will be any changes to qualified immunity. And then according to the Detroit News, in a very recent article earlier this summer, there were bills that were introduced by House Democrats here in Michigan that would have proposed policy reforms, including limiting the use of qualified immunity. Representative Tanisha Yancey from Harper Woods chairs the House Democratic Caucus, and she held a press conference back in June outlining her proposals. The legislative process is long, and no one can predict what might happen here in Michigan, but if you have an interest, you certainly are welcome to contact your local legislator to see where she or he stands on legislation like that and to ask questions. Now, according to the Michigan Association of Chiefs of Police, they indicate that Michigan has already banned no-knock warrant use by police in our state, and that chokeholds are considered deadly force, and that qualified immunity only shields officers and public officials from civil liability rather than criminal suits. So in closing, I also just would like to thank our students, Emily and Brooke. I want to thank WHPR TV for allowing us to present information here today. And finally, we are grateful to Innocence Maintained and Aaron Salters. Aaron lives his life by saying, better not bitter, and I think it's a great motto we should all ascribe to. Thank you so much.